Oh, hey folks, Elder Law Care attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, we've got a great question today from one of our YouTube subscribers. So let's get right to it. They say, Patrick, can you help us understand the filial or family responsibility laws? Folks, it's actually Massachusetts General Law, Chapter 273, Section 20. It's actually on the law books here in the Commonwealth saying that if your elderly parents are incapacitated and indigent, the child, so long as the child has the financial means, is legally financially responsible for their indigent, impoverished, incapacitated parent. The state's saying, hey, we don't have to pay if the children are financially capable of paying the bills for the indigent, incapacitated parent. It's on the law books. The good news, folks, it is not enforced. There is no Family Responsibility Act police enforcing that. Elder Services is not enforcing that, although it's on the books here, folks. So let's talk about a couple of states in my research that actually may do or possibly do enforce it, and that's Pennsylvania and South Dakota. So if you don't live in Pennsylvania and South Dakota, you typically are not going to have to worry about the filial responsibility laws. The state has to get involved. They'll likely end up on Medicaid or Mass Health here in the Commonwealth, and it will not be your responsibility. But let's talk about, I broke it down into three categories. Morally, as a child of an elderly parent, do you have a moral obligation? That's a personal decision, right? Also, ethically, let's talk about that. Do you have an ethical obligation to your parents? If your parents created an estate plan, if they named you as their durable power of attorney agent, you are now a legal fiduciary. So yes, I would say you have a fiduciary legal obligation. Maybe even if you were their healthcare agent, whenever you're a fiduciary, whether it's an attorney in fact under a power of attorney, whether it's a healthcare agent under a healthcare proxy, whether you're the executor of their will, personal representative of their will, or the trustee of their trust. They're all fiduciary roles where you have the highest duty of loyalty to act in the best interest of the beneficiaries or the principal who created that power of attorney or healthcare proxy. But keep in mind, those roles are typically voluntary. You can resign as well. If you decide to do that, make sure it's known, put it in writing that you're resigning as the fiduciary. Legally, folks, let's talk about legally. We talked about Mass General Law, Chapter 273, Section 20. Even though it's on the books here in the Commonwealth, it's not enforced. There is no Elder Law Services or Filial or Family Responsibility Act police that are going to monitor and prosecute. If you have the financial means, but you're not taking care of your elderly poor parents who are incapacitated, but this is where you need to be careful from my experience. If you're the healthcare agent or you're just a caring caregiver child, you do not want to personally sign admissions agreements in homes or memory care units or any facility, because oftentimes if you're signing that admissions agreement personally, if you're checking your incapacitated parent in on a weekend or a night and they have availability at the nursing home or a assisted living facility and they hand you the paperwork and you just start signing away, I've seen cases where if your loved one, could be a spouse, could be a parent, if they get on Medicaid benefits to help pay for their long-term care needs, but usually the Medicaid application process can take several months. So long and short of it, if there's a gap in financial coverage to that facility, I've seen cases where the facility's attorneys will do a collection action against a person who signed that admissions agreement. So my advice, my recommendation is do not sign anything. If your loved one, if your parent has the cognitive capacity to sign themselves any admissions agreement, you want to have them sign. If they're not able to sign themselves, then you should never sign personally, is my recommendation. But if you're the power of attorney agent, sign under your office as attorney in fact and never personally, because then you could become personally liable. So be very careful there, folks. So that is it right there, folks. Hopefully this was helpful. And this is a very interesting question, and I'm glad our subscriber sent it in. Speaking of subscribing, be sure to click the subscribe button at elderlawcare.com and click that notification bell now, because we'll continue to keep you updated on other important elder law subject matter. Folks, if you like to read, strongly recommend pick up a copy of my books on Amazon. First book right here, Patrick Kelleher, How to Slay the Four-Headed Beast of Elder Law, Probate Court, Taxman, Financial Creditors and Predators, and yes, that $18,000 per month nursing home. And very proud of the second book right here, 20 Strategies That Will Win You the Battle in Elder Law, recently released on Amazon as well. Folks, see you next time at elderlawcare.com.